case before the court is a case concerning the Sisters of the Sun. The parties are applicant, the Federation of the Clans of Aten, and the respondent, the Kingdom of Rahat. The applicant and the respondent are each allocated 45 minutes to present their pleadings.
Applicants, when you're ready, we are ready as well.
Mr. President, Your Excellencies, my name is Kristina Franchuk, and I am deeply honored to appear before the International Court of Justice for the Federations of the Clans of Aten, the applicant in this case. I'll speak first for 21 minutes and cover the first two submissions of applicant concerning the extraction of water from the Kretinata aquifer and the international obligations of Rahat with respect to the Kincanyon complex. My co-agent, Vitaly Trachuk, will speak second for 21 minutes as well, and will cover the remaining two submissions of applicant concerning the repatriation of cultural property and the compensation for migrants' outposts. We also kindly ask the court to reserve 3 minutes for our rebuttal. Let me also introduce our off-counsel, Denis Bykov. Your Excellencies, the case before the court concerns the fundamental issues of international law, going very hard to the allocation of water resources and to dealing with migrant crisis. And thus the judgment in the present case will be vital for states in the present proceedings, as well as for future development of international law. And if I may, I would like to start with the first submission. Your Excellencies, in order to face the drought conditions, Rahat started to utilize water from the shared resource, the Kretinata aquifer, and the following issues arise from these facts. Firstly, that such extraction of water violated its international obligations on equitable and reasonable utilization of shared resources, and secondly, the no significant harm rule. So I will now discuss these arguments in turn. So as to the equitable and reasonable utilization, we base this argument on two main grounds. Firstly, on the unilateral declaration made by the Rahadi minister in 1993, and secondly, on the customary international law. As to the unilateral declaration, in 1993, the Rahadi minister made a statement, and I quote, that Rahat promised to make every reasonable effort to preserve and protect the shared freshwater resources in a normal cost, and to ensure its equitable use, end of quote. And it is the position of the applicant that such statement of such a nature can bind a state if three cumulative preconditions defined in customary international law are fulfilled, such as the authority, the intention shown by this authority to be binding by such statement, and whether the statement is clear and specific enough.
With your permission, Mr. President, in the statement quoted here, it was mentioned that we are ready to, that the Rahat is ready to do all possible to preserve, but there was nothing said about not using at all.
Indeed, Your Excellency, it was stated that they will use every reasonable effort, and this means that Rahat was obliged to equitably and reasonably utilize the aquifer, but not that they are prohibited to utilize the aquifer itself. Also, the Rahadi minister was a proper authority to make such binding statements. We do recognize that there was a consistent practice of this court where only head of states, head of governments, and minister of foreign affairs were authorized to make binding statements. However, this court in 2006 judgment in the armed activities in territory of Congo at paragraph 47 specified that in light with the development of international relations, other persons can make binding statements if they fall within their purview.
Agent, who was the person making the statement in the armed activities?
The Minister of Justice of Rwanda, and it made a statement concerning the reservation concerning human rights. And in the present case, the statement was made by the Minister of Water and Agriculture, and we submitted such statement concerning the management and allocation of water and all shared resources indeed fall within the purview of this minister. We secondly submit that this minister had intention to bind Rahad upon his statement. And it was pointed out by this court in the nuclear test case of 1974 at paragraph 51. In order to see the intention of a state, the following factors have to be considered: factual circumstances, their context, and reaction this statement gives to international community. And I will show that these factors are present in the case at hand. As it was seen in the paragraph 16 of the compromise, the statement was made in the context of a joint ceremony when two governments were present, the government of Athenia and the government of Rahad. Also, as we see...
Excuse me, agent. Doesn't it amount to a form of treaty then? If they are together and they just don't write it, couldn't it be more a form of a reciprocal obligation and not a unilateral one?
No, Your Excellency, it is the position of the applicant and respondent contested in its written submission that it was not a unilateral declaration. So for the purposes of the present proceeding, we consider this as a unilateral declaration. And moreover, as we see from paragraph 16, there was a reaction of the Athenian government where they recognized such commitment of Rahad to use these water resources.
Exactly. Turning back to my learned colleague's question, if one state says something and the other accepts it, it's a treaty. It's not a unilateral declaration.
I do understand your concern, Your Excellency. However, the conclusion of a treaty significantly differs from the unilateral declaration, and we submit that there was a reaction and international community in the guiding principles on unilateral declaration specified that in order for considering the statement as binding, there also has to be reaction, but not the acceptance.
No, I think you're still avoiding the question whether a treaty can be concluded by two parties coming together and agreeing on something.
Your Excellency, I understand your concern, however, we cannot conclude the facts of the case that there was a treaty.
So what is the definition of a treaty?
When there is agreement between two states, but Athenian government did not agree, they only recognized the commitment.
There was an offer and an acceptation.
I would like to clarify the facts of the case, that there was no offer. They only made a unilateral statement that they promised to preserve and protect the resources, but
it
not
was
the
done during a ceremony with the participation of Athenia and was led by the actual reciprocal answer from the Athenian minister. So how do you say that it is not a treaty, a gentleman agreement?
Because as we see in the practice of this court, treaties were usually concluded in the context of bilateral negotiations when they sit down and negotiate on the certain
Only
provision.
during the bilateral negotiation?
No, Your Excellency, or as we see from other examples on the meetings of the UN General Assembly. But in the case at hand, there were no such circumstances, and it was a unilateral declaration made towards Rahadi citizens, which has to oblige Rahad upon the reaction of the state.
Does Donald Trump oblige the people of the United States by writing on Twitter?
Yes, Your Excellency, we can consider such statement because in the light of modern developments, we can consider.
So all the tweets that Donald Trump writes at 3 in the morning create binding obligations on the United States?
If the conditions defined in the UN Guiding Principles of Unilateral Declaration are fulfilled, when there would be clear and specific terms, when it would be a proper authority, which is apparently present in the situation with Donald Trump, and rather there would be reactions of other states. And finally, we submit that the statement at hand was clear and specific enough, because Rahadi minister promised firstly to preserve and protect the shared resources, to ensure its equitable use, and to transfer the aquifer and the shared resources to future generations. And taking all this into conjunction, we submit that Rahad is indeed bound by its statement.
Was bound. Was
Yes.
bound
Yes,
because
Your Excellency.
it seems to this court that they might have withdrawn that declaration if it is a declaration and not a treaty.
Your Excellency, we see that the government of Rahad was present when the declaration was made, but no reaction received from the government.
I'm talking to you about the declaration from 2 February 2003.
Yes, Your Excellency, but we cannot consider such declaration neither as a form of withdrawal from declaration under the fundamental change of circumstances concept under the Vienna Convention law of treaties,
Exactly, it's not a treaty. But, so whether you apply Vienna Convention law, the treaties, why can't Donald Trump write another tweet saying I didn't mean what I said?
Regarding your first question concerning why we can't apply the Vienna Convention law treaties, as it was pointed out by the International Law Commission in its guiding principles on unilateral declaration, a state can use the concept of the fundamental change of circumstances as the mere interpretation of it. So if Rahat would rely on such ground, the court indeed can rely on the grounds enlisted in Article 62 of the Vienna Convention law treaties. But we also alternatively submit that if the statement is not binding by the statement of Rahat minister, Rahat was obliged to equitably and reasonably utilize the aquifer under the customary international law. While there is an established customary rule with regard to watercourses, we submit that a new rule had emerged with regard to aquifers. And I will show that both elements defined by this court in the North Sea continental shelf case in paragraph 74 are fulfilled, namely the consistent and widespread state practice and opinion juries. So as to the state practice, the first agreement concerning the transboundary aquifers was concluded in 1977 between France and Switzerland concerning the Genovese aquifer, and the latest one was concluded between Jordan and Saudi Arabia concerning the Aldisi aquifer. And all these agreements, if not specifically including the provisions, they all are aimed at equitably and reasonable management of this aquifer.
Are you saying that these agreements are state practice?
Yes, Your Excellency, indeed, it can be regarded as a state practice as it was.
So if two states, France and Switzerland, conclude an agreement, then they act in pursuance of that agreement, not according to what they feel customary international law is.
And I will now prove that the state believes that such practice of states is accepted as law, and there is an element of opinion juries. And this element is proven by the resolutions of the General Assembly, for instance, A/63/10 and A/63/100.
How many states voted in favor of those resolutions?
No one dissented from this resolution.
How many voted in favor?
Your Excellency, 124 states.
Okay.
And I'll briefly now show that Rahat failed to include and to take into account the provisions defined in these emerging rules of customary international law.
But should we take into account the practice of all those 124 states?
Your Excellency, the court can rely them as on the emerging rule of customary international law, because all these agreements include the provisions.
Even if those states don't have transboundary aquifers?
They have, Your Excellency. I would like to clarify that all these agreements were concluded with
The agreements, but I'm talking about the states that agreed to the resolution of the General Assembly. Those states, do they all have a situation in which they have a transboundary aquifer?
If a state has transboundary aquifer, they are not obliged, but they are called to utilize.
So we can take into account their practice if they have an aquifer that is transboundary. If not, we shouldn't take it into account, shouldn't we?
It is the position of the applicant that we ask the court to apply the practice and the position of the states that regulate the management of transboundary aquifers. And
so what is this practice again? Signing treaties. The practice is you have a transboundary aquifer, you sign a treaty with the other country, and you decide what you're going to do with it.
Your Excellency, I would like to clarify that after such treaties were concluded, the International Law Commission adopted a draft articles on transboundary aquifers.
And what is the legal value of that?
It is the interpretation of the customary rule of international law on equitable and reasonable utilization in a manner that this rule would apply to aquifers.
Are all ILC draft articles reflecting existing customary international?
No, Your Excellency, only Article 4 concerning the equitable and reasonable utilization, and Article 6 concerning the no significant harm rule, as it was pointed out by the Special Rapporteur for the International Law Commission, Jusei Yamada. So I would like to show that Rahat failed to establish a comprehensive utilization plan including alternatives, and failed to maximize the long-term usage of the aquifer, as it is and listed and defined in Article 4 of the draft articles. Indeed, as it is stated in paragraph 26, Rahat had a utilization plan and extracted water at a rate of 1.2 cubic kilometers. However, Rahat failed to include any alternatives in this plan and therefore failed to comply with requirements to maximize the long-term usage of the aquifer. Moreover, since the aquifer is non-rechargeable one and non-renewable, it means that if Rahat would continue at the same rate, it would completely be depleted in 30 years. And moreover, Rahat used the water from the sole source of fresh water between two states for gas industry for 22%. And taking all this into consideration, we submit that Rahat failed to equitably and reasonably utilize that.
All your arguments, in my opinion, was dedicated to the issue of non-reasonable use. What about the second the element?
Equitable use.
Equitable use.
Your Excellency,
Because all your arguments was dedicated to the non-reasonable use, using for the gas, using for the other resources, no alternatives, so no thinking about the future generation. What about the equitable use?
The International Commission pointed out in its resolutions that these two statements, the equitable and reasonable, have to be taken into conjunction, and in order for a state to show that they comply with this equitable and reasonable rule, such factors as the vital human needs, the maximization of the long-term usage of the aquifer, and other such factors have to be considered. Your Excellency, now I would like to move to the second submission. I would like to show that with the extraction of water from the aquifer, Rahat not only violated the international obligation with respect to aquifer, but also with respect to the King Canyon complex. In our second submission, I'll make two main arguments. Firstly, that Rahat violated its international obligations with respect under the World Heritage Convention, and secondly, its actions cannot be justified by the state of necessity. So as to the World Heritage Convention, we do submit that while causing damage to the World Heritage Site and while continuously operating the Savali pipeline operation, Rahat violates provision of Article 6.3.
How do we know that Rahat actually caused damage to the World Heritage item?
It is stated in paragraph 30 of the compromise when the International Panel of Geologists, Climatologists and Hydrologists found that the extraction of water from the aquifer caused the structural degradation of the
So what's the value of the report of geologists and so on?
Your Excellency, it has to be regarded as sufficient evidence for establishing the causal link between the actions of Rahat
So
and...
if Rahat had a panel of geologists that said we did not cause damage, who should we refer?
Your Excellency, I would like to clarify that it was the International Panel of Geologists.
Well, it's probably Athenian geologists and your friends geologists. That's also an international panel. How do we determine which experts are more believable?
Your Excellency, as it was pointed out by this court in the Genocide Convention case in 2007, there are criteria defined in order to establish whether the court can rely on these reports, and among them is the nature of the report and in a manner how this report was generated. And since Rahat deliberately took measures that even potentially can cause damage to the World Heritage Site, we submit that this obligation was violated. And
Well, is the obligation the same with regard to the part of complex in your territory and the part of the complex in their territory?
there are two different obligations under Article 4 concerning the own territory of Rahat and Article 6.3 concerning other territories.
First, do you have standing to invoke their damage they did to their own territory?
Yes, indeed, Your Excellency. Under the erga omnes partes standing as it was defined by this court in its recent decision concerning Belgium versus Senegal, when states are parties to the single convention, for instance the World Heritage Convention, then they can invoke standing of erga omnes partes. So I would like to move to this argument concerning the 6.3 requirements. And I would like to show that the World Heritage Committee, in its decisions of 2011 concerning Kenya and in decisions concerning 2016 in December concerning Uganda, they pointed out that actions that are likely to cause damage are also violation of rule prescribed in Article 6.3. And since
So the deliberate damage is the same as likely to cause damage?
we cannot take from the context the sole word of deliberate, we should look into the whole sentence.
Why?
Because under Article 31 of the Vienna Convention Law of Treaties, and it is stated that deliberate measures that might directly or indirectly cause damage to the World Heritage Site. And then the Commission stipulated that even the measures that are likely to cause damage are a violation. And briefly, I would like to say that Rahat cannot rely on the state of necessity as it was done by them in their written submissions, because firstly, as it was defined by this court in the Gabčíkovo-Nađamarš case in paragraph 185, when a state has alternatives, even enormously expensive, it is still alternatives. In the present case, Rahat could have imported water from other countries. Rahat could have used water from the Emerald Ocean and used the practice of states that are located near it, for instance, to use only for gas industry and not to waste it for other purposes. And also could have used the example of Atenia and implement the licenses policy to regulate the management of water in its country. And therefore, since there is a violation of international law, and such international wrongful act is not justified by the state of necessity, we claim that such operation has to be ceased under Article 31 of the Articles on State Responsibility. This concludes the first two submissions of applicant. Thank you for your kind attention, and may it please the Honorable Court.
Thank you.
Good afternoon, Mr. President, Your Excellencies. My name is Vitaly Trichuk, and I have the honor to appear before this court for applicant, the Federation of the Clans of the Atan. I will cover applicant's third and fourth submissions with regard to repatriation of the ruby seeper and compensation allegedly owed by Atenia to the Kingdom of Rahat in relation to accepting members of Clan Kin. If it may please the court, I will start from the third submission of the applicant. And in this submission, we will argue two main points. Firstly, that under existing international law, Rahat is obliged to repatriate the ruby seeper. And secondly, that Atenia is indeed the lawful owner of this artifact pursuant to the UNESCO 1970 Convention on the Prevention and Prohibition of Illicit Import, Export and Transfer of Ownership or Cultural Property.
But does Rahat really dispute that you are the lawful owner?
Your Excellency, it is position that the ruby seeper may be repatriated only to the lawful owner, and if the court is convinced that Atenia is the lawful owner, I will focus on the argument with regard to obligations of Rahat.
We're not convinced of anything, but I think that Rahat does not dispute the fact that you are actually lawful owner, and you're trying to prove to us that you are. In other words, does this court have authority to rule on something that is not disputed?
May I clarify, Mr. President, that according to the facts in the compromise, when refusing to repatriate the ruby seeper, a respondent described it as lawful ownership of Rahat, and this is why we brought this.
Point out the exact paragraph.
Your Excellency, unfortunately, I cannot point out the exact paragraph. However, it is stated. It has been stated by Rahat when it refused to repatriate the ruby seeper.
Yes, but on several other grounds, not because of the ownership issue.
It was also stated that in order to preserve the ruby seeper for public display and from the threat of destruction. In that respect, Your Excellency, it is our position that there is no threat of destruction in the present case, since taking into account the statement of President Van, who stated that replicas of the ruby seeper must be destroyed, we cannot conclude that the ruby seeper original would be intended to destroy it. The ruby seeper original was put in storage, and we may reasonably conclude that such putting in storage was used to preserve such artifact in the situation of the Kin protest crisis. And turning to the arguments on obligation to repatriate, Your Excellencies, we'd like to clarify that we do understand that Article 7 of the UNESCO 1970 Convention, which prescribes mandatory repatriation, is not applicable due to its specific non-retroactivity. For this reason, we ask the court to find that the ruby SIPA has to be returned to Athenia as a remedy for violations of international law on the part of Rahat. Namely,
Yes, please.
we submit that Rahat violated Article 18 of the Vienna Convention by defeating the object and purpose of the UNESCO 1970 Convention, and that it violated its obligation to repatriate under customary international law.
Just one question concerning the very moment of appearance of ruby SIPA in the territory of Rahat. As we remember from the compromise, it was before the entry into the force of 1970 UNESCO Convention for Rahat. How you can refer to this convention?
Your Excellency, may I clarify that we do not make reference to the substantive provisions under this treaty. We ask the court to find the defeat of the object and purpose of this
Why
treaty.
was
Under-
Rahat bound by the object and purpose at all?
It is stated in Article 18 of the Vienna Convention, to which both states are parties, that states must refrain
Which
from...
part of Article 18?
It is stated in paragraph 1 of Article 18.
You mean paragraph A, which talks about signature of the treaty?
And paragraph B, Mr.
So which one
President,
are you referring
to the both of them, Your Excellency, since this...
to? When did Rahat sign the treaty?
On 13 September 2000, pardon me, Your Excellency, the compromise signed on the issue when Rahat signed the treaty, but it ratified the treaty on 13 September
So
2014.
it only ratified, never signed, therefore was never bound by the object and purpose under Article 18 of the Vienna Convention.
Not exactly, Your Excellency. Pursuant to paragraph B of Article 18 of the Vienna Convention, a state who ratified the treaty
Can you cite the language of Article 18b?
Your
Does
Excellency,
it talk about the state who ratified the treaty?
yes, indeed, Your Excellency. It talks about the state who ratified the treaty. It stated that the state is obliged to refrain from acts which would defeat the object and purpose of a treaty, that it has signed the treaty or has exchanged instruments constituting the treaty subject to ratification, acceptance, or approval until the treaty enters into
That's
force.
part A.
Yes, Your Excellency. Pardon me. That is part
But
A.
we figured that there is no signature and exchange of instruments, right?
There is an exchange of instrument of ratifications pursuant to the clarification, correction 3 to the
Could you
compromise.
define or just explain what means an exchange of instruments?
Your Excellency, it would be the deposit, with regard to the UNESCO Convention, it would be the deposit of the instrument to the specially
There is no
created...
exchange. You just deposit something.
Yeah.
If you exchange, then one state gives its instrument of ratification, the other one gives it back.
For
Like it-
instance, you can be at a conference and just give an oral offer and an oral acceptance and have a treaty.
Your Excellencies, it has been stated in the preparatory work to Article 18 that it is a practice that when there is a specific authority created under the treaty, the exchange of instruments of ratification is conducted through such authority, as was in the present case. And turning to the object and purpose argument, Your Excellencies, it is our contention that by approving the illicit import of the ruby SIPA, by therefore manifestly encouraging such practice without taking any measures against Carla Duga who stole this object, and by flagrantly refusing to repatriate this ruby SIPA, the respondent violated the object and purpose of the UNESCO Convention, which is to oppose all practices of illicit import, export, and transfer of ownership over cultural property. We do understand that one has to distinguish between violations of the substantive obligations and by defeat of the object and purpose.
Could you
But we-
explain what is the object and purpose? Because it sounds like it's exactly the same as the convention.
I understand your concern, Your Excellency. However, as is stated in the preparatory work to Article 18 of the Vienna Convention, the object and purpose may be taken from the name of the treaty, from its preamble, and from its text. And it is our submission that the object and purpose of the UNESCO Convention is to oppose all practices of illicit import, export, and transfer of ownership or cultural property.
The very aim of creation of this convention was the better protection of cultural property. And from this perspective, and the current state practice, especially concerning with the Museum of Iraq and Syria, shows that it's not always it is the best way to repatriation of this property to that countries because of the threat of being destroyed and somehow demolished. So, what's your point of view?
It is our position, Your Excellency, in that respect that there was no threat of destruction in Athenia with regard to the ruby separ, since it was only put in storage. And
That the very replicas of the ruby separ is prohibited.
yes, Your Excellency, but we should interpret the statement of President Wan in good faith, and since President Wan stated that the replicas would be destroyed, it doesn't mean that the ruby separ original would be destroyed, while in the present case it was only put in storage, as we may presume for the aim of preservation of this artifact.
So if we were to accept completely your understanding of object and purpose, could you again reiterate what are the actions that are prohibited to do in case of ruby separ?
It is our contention that by approving the illicit import of the ruby separ and therefore manifestly encouraging such practice by private persons and then flagrantly refusing to repatriate the ruby separ, respondent defeated the object and purpose of the treaty, which it's...
So you concede that the importation itself is not attributable to Rahad?
Yes,
so
Your Ex-
basically
yes.
the only thing that they did wrong was they didn't give it back to you.
Not only that they didn't give it back to the Federation, the clans of their town, but also that they manifestly encouraged
But
such
even
practice.
even if you talk about the convention's substantive provisions, there is no substantive provision that precludes manifest encouragement of such practices. How can you say that object and purpose is something more than substantive provisions of the convention?
Mr. President, under the convention, a state is obliged to implement legislation, which is with the aim of which is to prevent and prohibit such acts. And it is our position that when a state manifestly encourages such practice, it amounts to the defeat of the object and purpose. But in alternative, Your Excellency, we submit that there is customary obligation to repatriate cultural property to the countries of origin. In order to prove an existence of a customary rule, a state has to demonstrate a sufficient amount of state practice and opinion juris in that respect. With regard to state practice, as was stated by Professor Malcolm Shaw and Judge Crawford, a treaty which is widely recognized in international law may be an effective evidence of state practice. And
In this case, this treaty should be considered as the manifestation of the existence of such practice. How many state parties we have?
at this date, Your Excellency, there are 131 state parties to the UNESCO Anti-Semitic
And
Convention.
how many members, UN members, we have now, these recognized states?
Your Excellency, unfortunately, I am not aware of the exact number of the state members to the United Nations.
A little bit more.
Yeah, indeed, Your Excellency. However, we submit that since this treaty is indeed widely recognized, taking into account the great amount of state parties, it is an evidence of state practice. But
you do see the problem with that argument. If there is a treaty not signed by some countries and then those countries are bound because a lot of other countries have signed. So how do you get around this problem?
Mr. President, in that respect, we would also like to show the sufficient amount of state practice not covered by the UNESCO Convention. For example, in 2010, Japan repatriated more than 1,000 artifacts to South Korea, which were stolen during South Korean occupation in 1940s. Also in 2006...
In time of war, so in another context. Do you have an example or a precedent in time of peace?
Your Excellency, firstly, this repatriation was conducted after the
Yeah, but it was stolen in time of war, as an act of war.
Yes, Your Excellency, but we refer to such case since it was indeed stolen and thus it was the illegal...
The protection of cultural property during the peacetime and in time of war regulated by international law under the different bodies of law. So how you can use the logics of the Korean case in this case?
Because, Your Excellency, that the repatriation itself took place not in the context of armed conflict, and the context of international humanitarian law, a state is obliged to protect cultural property pursuant to the Hague Convention, which was not considered by Japan when it repatriated cultural property, as well as by the United Kingdom, Sweden, Norway, Canada, and the United States when they repatriated more than 2,000 cultural objects to Afghanistan. Additionally, Your Excellencies, we would like to show the sufficient amount of United Nations General Assembly resolutions, namely more than 30 ones, which encourage states to take all appropriate measures to facilitate in the most effective way the repatriation of cultural property to its countries of origin. For example, the most recent Resolution 1 adopted on 5th December 2015. Therefore,
Could we talk about the refugees a little bit?
Indeed, Mr. President. And turning to the final submission of applicant, it is our contention that applicant owes no compensation to Rahat in relation to all expenses incurred or accruing as a result of accepting members of Clan Kim. Because in order to obtain compensation, a state, under the law on state responsibility, has to demonstrate the fulfillment of three necessary requirements: the existence of an injury to a state, the existence of a causal nexus between the injury and the acts of another state, and finally, the international wrongfulness of the acts of another state. But if the court would allow me, before turning to these substantive requirements, I would like to draw the court's attention to the very important issue of standing in this case. Because pursuant to its written submissions, respondent
excuse me, Agent. Your colleague pleaded before erga omnes partes. So either you stonewall your colleague or you continue on that argument. But I advise you to take care about what you were going to say.
Indeed, thank you, Your Excellency. My colleague, my co-agent, referred to Belgium versus Senegal case when the court allowed to exercise standing under erga omnes partes pursuant to Article 48 of the Articles on State Responsibility, when a non-injured state may request, firstly, cessation of the unlawful conduct, and secondly, compensation to be paid to the beneficiary of the obligation, namely the injured nationals. While pursuant to the compromise, respondent requests compensation to be paid for its own expenses, and thus is deprived.
In the second issue, what you were really asking for was money to be paid to your nationals which are injured by degradation of cultural property?
No, Your Excellency, within the context of the second submission, applicant requested only cessation of the supply pipeline operation. And therefore, since the respondent requests compensation for its own expenses, it must establish an international wrongful act with regard to obligations owed between the two states. In its written submissions, respondent realized that it is an injured state, but an injured state may request compensation and exercise its standing only with regard to human rights violations, and in the present case, respondent submits, only when it exercises all available local remedies in another state.
What about specifically affected states?
Indeed, Your Excellency, the respondent relies on that it is a specifically affected state pursuant to Article 42. But it is our contention that even in such case, when a state brings a claim with regard to human rights violations pursuant to Article 44 of their SIVA, it must exhaust all available local remedies. The local remedies rule was recognized by this court as customary international law in Barcelona Traction case, in Interhandle case, and is recognized in the ICCPR in Article 42. As was stated by European Court of Human Rights, exhaustion of domestic remedies obliges those seeking to bring a case before the International Tribunal to use first the remedies provided by national legislation, because there is an assumption that the breach in domestic system can be effectively considered by domestic courts.
Basically what you would need to prove to us, and I don't think we have enough information for that, is that Athenia had legislation that would have permitted Rahat to come into Athenian courts and plead human rights violations on behalf of the Kin people. Do you have such remedies?
Your Excellency, firstly, there is no indication in the compromise that we do not have such remedies, and secondly, it was stated in the Agdiva versus Turkey case by the European Court of Human Rights that the domestic remedies rule applies even in those cases when there is a signed international treaty, but this treaty is not incorporated into domestic legislation, since signed international treaty can form the part of the domestic legislation of the state itself. Therefore, Your Excellencies, it is our contention that respondent lacks the necessary locus standi before the International Court of Justice to claim violations of human rights before this international tribunal.
But as far as we remember, the violation of human rights is not the basis of the claim. The basis of the claim is just damage which caused by the influx of a lot of people to the territory of Rahat.
In that respect, Your Excellency, a state respondent would have to demonstrate the violation of interstate obligations, such as it may be argued that that would be the rule of territorial sovereignty or the rule of obligation to provide socio-economic assistance to the state. And it is our contention that the rule of territorial sovereignty of Rahat was complied with by Athenia, because the rule of territorial sovereignty may be violated only when there is a use of force, prohibited intervention, or unauthorized entry into the sovereign area by another state's agent.
Since under the UN Refugee Convention, Rahat is under obligation of non-refoulement, so it is impossible for Rahat to send these people back.
Thank you, Your Excellency. That brings me to our argument concerning the causal nexus, because it is our contention that respondent was not obliged by the non-refoulement principle to accept the Kin migrants, because firstly, they are not refugees under the Refugee Convention, and secondly, because they are not covered by complementary protection in international law.
Is there an obligation to accept asylum seekers, not only refugees?
It is. There is no such obligation, Your Excellency.
So basically, if somebody comes to your border and says, "I am an asylum seeker," you say you're not a refugee, go away. Is that your understanding?
It is a state. It is on discretion of the state whether or not to accept asylum seekers.
But how does a person become a refugee? Who determines that?
Your Excellency, a person becomes a refugee if it can establish a well-founded fear of being persecuted for reason of membership in a particular social or ethnic group.
Is that an objective criterion where somebody has to say, yes, you correspond to all these criteria, therefore you're granted refugee status?
As was stated by United Nations High Commissioner for Refugees.
Now,
and
if
by
you look
United
at the
States,
convention, the Refugee Convention itself, what does that say?
It is our contention that this is an objective criteria, and a person has to objectively satisfy the requirements of well-founded fear of being persecuted for reasons of belonging to a particular group.
So, no, but technically, I would like to understand how this works. So, a boat of people comes over the Mediterranean to Italy, and every person has to indicate that I'm persecuted and so on to the border guards, Italian border guards, even before they're allowed into the country. Is that your understanding? Otherwise they can be pushed back?
I understand your logic, Your Excellency. However, in the present case we can see that after accepting the Kin migrants, respondents started to bear enormous economic burden. And if it could not bear such expenses, it could have expelled those migrants, since it was not obliged to expel them under the non-refoulement principle. It is our contention that the motivation of the alleged persecutor has to be considered in determining the well-founded fear of persecution. While in the case at hand, the sole motivation of Athenia was to implement water licensing policy to deal with drought conditions and over-exploitation of the aquifer, and thus it does not amount to persecution under the Refugee Convention. Additionally, if a persecution has to be in violation of international human rights law, while inability of a state to provide sufficient amount of food or water to its nationals cannot constitute a violation.
Thank you.
That concludes the arguments. May it please the Honorable Court.
My co-agent, Olga Bozhenko, will be presenting the remaining two submissions of the respondent, while my co-agent Ms. Nazreen Hussain-Zadeh will be staying off counsel for today. Your Excellencies, respondent allocates 21 minutes for the first two submissions, 22 minutes for the remaining two submissions, and 2 minutes for the rebuttal. Your Excellencies, I will now proceed to the first submission of the respondent, and may it please the Court. In its first submission, respondent argues that its extraction of water from the aquifer does not violate international law. Your Excellencies, respondent makes 3 arguments in support of this submission. The first one, stating that by extracting water, Rahat acted within its sovereign right. The second, stating that Rahat did not violate any limitations imposed by international law upon its sovereign right. And the third, stating that respondent did not violate international law by diversion from its unilateral declaration. Your Excellencies, as regards the first argument, the principle of permanent sovereignty of states over the natural resources in their territory was first confirmed in the General Assembly Resolution number 1803 and recognized by this Court in the case of armed activities on the territory of the Congo as a customary rule of international law. The applicability of this principle to shared resources is confirmed by a general practice of states, namely the agreements on international water courses such as River Chad, Mekong, Niger agreements, and a lot of other river agreements enshrines this principle. And what is more, the ILC draft articles on transboundary aquifers and the Guarani Agreement on a transboundary aquifer also contain the recognition of sovereignty of states over shared resources. Your Excellencies, in accordance with the principle of sovereignty over shared resources, a state can use its natural resources in its territory in the interest of its development and to ensure the well-being of its population. It is clear from paragraphs 24 and 26 of the compromise that the pipeline project was conducted on the territory of the respondent.
See, there is a problem with your argument. If this is the aquifer and I use it on my territory on this side, then his territory on this side will become emptied out. So there are limitations to that, right?
Yes, a respondent absolutely recognizes that there are limitations upon sovereign right to use a shared resource, and what we are stating in the first argument is that by developing natural resources in our territory and in the interest of our economic needs and in the needs of the population, we acted within the sovereign right. And in the second argument, which I will now proceed, we state that we did not violate any limitations imposed by international law on such sovereign right. Namely, the applicant referred to the requirement of equitable and reasonable use of a shared resources. Your Excellencies, the requirement of equitable use is indeed the customary international law applicable to shared resources. However, this requirement means that shared resources, that states have equal rights to use shared resources on the basis of their needs. And in the second argument, the respondent argues that it used this resource in accordance with its needs and did not impair Tanzania's rights to use the resource. Namely, Your Excellencies, it is clear from the facts of the compromise that, namely paragraph 3 of the compromise, that Rahad is a developing country, largely dependent upon its natural gas industry. And what is more, during the first drought conditions on the Nomad coast, Rahad was forced to permit drilling wells into the
Sorry, where does it say that it's a developing country?
If I'm not mistaken, Excellency, in paragraph 3 of the compromise.
It says it's a constitutional monarchy. Is that the same thing?
Excuse me, Your Excellency, maybe it's paragraph 2 of the compromise.
It says about Tanzania, which is a newly industrializing state, whatever that means. But I think you're making up that Rahad is a developing country. How do you determine what is a developing country?
And why is it important as well?
Your Excellencies, basically, the fact that Rahad is a lower income country can be inferred from its GDP per capita, as it is about $3,100, and it is a lower income nation. And
Rahad's GDP per capita is lower than what?
Is lower than 300. Is about 300 and.
So there is some sort of.
$3,100.
So there is some sort of objective criterion. If it's below 3,100, then you're a developing country.
No, Your Excellency, it just generally means it's comparatively it's a lower income nation. And
compared to what?
Compared to the GDP per capita in the states in the world.
Okay, what's the GDP per capita of Ukraine?
If I am not mistaken, about 6,000 or something like that. In the richest countries, it's about 50,000, and in Rahad.
So there is a rule of international law that sort of slots countries into developing countries or not based on GDP per capita. If that is so, then what is the relevance of this?
No, Your Excellency, there is no such rule of international law. However, the requirement of equitable use takes consideration of the needs of the states which are dependent upon shared resources, and provided that Rahad is a relatively poor country and a developing one and hardly.
But compared to Tanzania, there are two countries, Rahad and Tanzania. Those are the only two countries which are concerned with. Their GDP per capita is almost identical. Is that correct?
USSR is about 400.
So these considerations of poor, underdeveloped countries apply to both countries, so it doesn't help you, does it?
Maybe, Your Excellencies. However, Atania, Atania is largely dependent upon its hydrocarbons industry, and Rahad is using this water, and it was not impaired by Rahadi use of water. However, Rahad is using this water to satisfy its industry upon which it depends exclusively, namely the natural gas industry. And this
But using the fresh water to support gas industry is not the best solution, taking into account the shortage of water worldwide. But in any case, I would like to ask the following question. Whether you are under any obligation, because we speak about shared resources, to contact, to communicate with Atania before starting to use the aquifer?
Your Excellencies, this requirement is not upheld by the state practice, since
What's the difference to use your territory, your sovereign territory, and use your sovereign territory, which actually simultaneously is a shared resource with other countries, neighboring countries?
Your Excellency, the state is indeed obliged to take into account the interest of the other state.
How did your state comply to this requirement?
Well, firstly, we did not preclude Atania's right to extract this aquifer, namely nothing precludes Atania from also extracting the water from this aquifer. And what is more, before...
Isn't it gonna destroy the King Canyon even faster if they also pump in it?
Your Excellencies, with the permission of this honorable court, I will address the issue of the King Canyon in the course of my second submission, if I may. And what is more, Your Excellencies, the Rahad, before constructing the pipeline and conducting it, undertook the study and developed the plan of utilizing this resource, and what is in accordance with the environmental impact assessment requirements as set forth by this court. And what is more, Atania was aware of the planned project.
But did you inform Atania of the plan? Did you get their consent? Did you negotiate with them?
No, Your Excellencies, we did not get their consent. However, as it was stated in the Lakeland arbitration, neither of the co-riparians has a right of veto upon the project of the other, and even if the agreement is not reached, the state may still proceed with its
But
project.
did you try to reach an agreement? Do you have an obligation under international law to try to reach an agreement?
Your Excellencies, even if this court states that there is a procedural obligation to enter into negotiations, Rahadi claim is that violation of a procedural obligation has no bearing upon the legality of the project itself, as it was stated by this court in the pulp mills case. Your Excellencies, the applicant also referred to the requirement of reasonable use and stated that...
Now, can we stay on the equitable a little bit? Because if we reach a decision in your favor, we will have to say what equitable means. Can you give us numbers? How much are you allowed to extract and how much we should leave for them?
Your Excellencies, it might be difficult with respect to numbers, but what the respondent draws the attention of this court to is that 65% of the aquifer is located within the territory of the respondent.
So 65-35?
Not exactly, since also respondent is more dependent upon this aquifer, as it is clear from paragraph 14 of the compromise.
So 70-30? How do we get the rule? 99-1?
Yeah.
Is there a rule? Is there
No, Your Excellency, there is no hard rule. There are only equal rights of states, and the respondent states that Atania has this right to extract water from this aquifer, and if there becomes a conflict of users, namely of who can extract how much, they can indeed negotiate it, but this is not...
So the rule is the one who pumps faster can get more until there is a problem?
Not indeed, Your Excellency. The rule is that a state has a right to use it as a resource, and an obligation not to preclude the other state from using it. Your Excellency, with your permission, I will now also draw your attention to the requirement of reasonable use to which my colleague referred is, well, with respect to the fact that this aquifer is geologically unsustainable and also contains a very scarce amount of water, the Rahadi water extraction plan, provided that it was priorly scientifically elaborated, was not unreasonable, and it is impossible in the circumstances to grant the access to this aquifer for the future generations due to the scarce amount of water.
Tell me, if when you're pumping it out at the rate of 1.3 cubic kilometers a year, how many years will there be enough water for you to pump?
For about 30 years.
How much?
30.
So it's the current generation we're talking about, not the future generation. So you're even depriving your current generation from future use. Isn't that excessive? Isn't that prohibited under international law?
No, Your Excellency, it is not prohibited by international law. There are a number of finite resources, and they are all used. And what is more, this aquifer, the amount of the water in the aquifer is simply not enough to cater for longer than one generation.
So even if you can continue to pump out water as much as you need, right? There are no limitations to that, because eventually it will come to the end.
Yes.
So even if there is a rule under international law to save it for future generations, you have no obligation to stop it when you no longer need it.
Even if there is a rule to save it for future generations, well, it can be recognized that sustainable development is a...
Well, will you stop at some point? Will you stop pumping?
Yes, if the drought conditions come to an end. It is
How do we know? How can we trust you?
It was stated by the Queen Teresa that...
How can we trust the Queen?
Well, the declarations made by heads of state should be interpreted in good faith.
Declarations made by ministers, how about those?
As is the declaration made by minister, we now proceed to that,
Yes.
to that statement, and they can be binding upon states, provided that they were made with the intention to be bound and in a clear and specific terms. And as regards the intention, it was confirmed by this court in the nuclear test case that it is to be interpreted from the substance of the declaration and from the context of its making. And the substance of the declaration did not specify any measures and did not even specify to which particular resources it was made. Namely, it stated about shared resources of the nomad coast.
It said shared fresh water resources of our nomad coast. Are there more than one?
There are no facts of the compromise on the point. And the declaration was generally made in a very in general terms which are typical for political declarations, and what is more, it was made on a celebration in the circumstances when there was...
During the celebration of what?
Of the Water Day.
So it is somehow not only political, but also...
Respectable of Your Excellency, since it was made in the circumstances when there was no full information as to the recharge rate of the aquifer and as to its water capacity, and it makes it even more unlikely that a state will restrict its freedom of action and assume such a burdensome obligation with respect to something about which there is a lack of the data. And the applicants also referred to the reliance on the declaration. However, the jurisprudence of this court is that the reliance is irrelevant for the binding nature of the declaration, since it would actually undermine its unilateral nature. And what is more, in the nuclear test case, this court, though Australia and New Zealand did not recognize the binding nature of the declaration made by France, this court ruled otherwise, and therefore the reliance of the addressees is not given due regard by this court. Your Excellencies, my time being short, I will now proceed to the second submission of the respondent, stating that the respondent has complied with its obligations with respect to the King Canyon complex. I will be making two arguments in the course of the submission. The first one stating that respondent complied with the World Heritage Convention, and the second stating that in any event, cessation is not an appropriate remedy in this case. Your Excellencies, as regards the World Heritage Convention, the applicant referred to paragraph 3 of Article 6 which requires state not to take deliberate measures which might damage directly or indirectly the heritage on the territory of another state. It is clear from the wording of this obligation that it is an obligation of conduct, since states are required not to take deliberate measures which might damage heritage, but they are not required to ensure that no damage exactly happens. And therefore, the mere fact of damage which occurred to Athenian part of the complex does not per se constitute the breach of such declaration. It was confirmed by this court in the Bosnian genocide case that the compliance of the state with an obligation of conduct should be assessed by a due diligence standard, and such diligence should be determined in concreto with a view to all the relevant circumstances.
So, deliberate measures not causing harm is the same as due diligence?
Excuse me, Your Excellency.
Your obligation under the convention is not to undertake deliberate measures that cause harm. And now you're saying that you can fulfill this obligation by observing due diligence principle?
Yes, Your Excellency, since the requirement...
And that's what the court said in the case you were referring to?
In the case of Bosnian genocide...
Yes, it's a bit different than...
Yes, it's a bit different. This court stated that the obligation to prevent genocide is of due diligence, since a state cannot be required to succeed in the result. And it is, in this particular case, also the state is not required to succeed with the result, but instead not to take deliberate measures which might damage the heritage. It's an obligation of conduct. And the due diligence in this particular case on behalf of respondent is clear, since the proper environmental impact assessment were conducted, and after the response indicated, they were submitted to the World Heritage Committee as it is required under the operational guidelines to the World Heritage Convention, namely the procedure of reactive monitoring.
Is this obligation to conduct EIA a once upon a time obligation, or if new risks appear, then you would need to carry out another one?
This court stated in Pulp Mills that it may be a continuing obligation, and Queen Teresa, in paragraph 33 of the compromise, undertook to monitor the activity.
Yes, but so when you realized that the canyon was crumbling, then should you have undertaken another EIA? Do you have an obligation under international law to do so?
Yes, a continuous EIA is an obligation, and the Queen Teresa stated that the activity would be monitored, and what is more, the respondent is currently engaged with the World Heritage Committee on the program of corrective measures, and therefore is continually adhering to its obligation. Your Excellencies, as regards the state of necessity to which the applicant referred, it is a speculation, since the respondent did not invoke a state of necessity in its written submissions, and neither is doing so in its oral submissions. It is just asking this court to take into account that the due diligence is to be assessed with a view to all the circumstances of the particular case, and in the circumstances of drought, it asks this court to state that since the respondent acted diligently and cooperated with the World Heritage Committee to do everything possible to divert such harm, it complied with its original obligation.
The King Canyon is still under in the list of the property under the danger. How it corresponds with your obligation to cease the operation?
Yes, Your Excellency. As to the cessation, only continuing on acts can be ceased. And the fact that the King Canyon complex is still on the list of World Heritage in danger does not mean that there is still danger. It just means that the complex has been
They just
damaged.
have forgotten to remove it, yeah?
No. According to the operational guidelines, the list of World Heritage in danger includes heritage which is threatened or damaged. And to repair such damage, this heritage still can remain on the list of World Heritage in danger. But according to paragraph 30 of the compromise, may I please conclude briefly?
You can finish the sentence.
According to paragraph 30 of the compromise, there is no evidence of further risk posed by the pipeline to the King Canyon complex. Your Excellencies, may it please the court.
Thank you.
Mr. President, Your Excellencies, my name is Olga Bozhenko, and it is my honor to appear today before the International Court of Justice in the case concerning the Sisters of the Sun. I will be speaking for the following 22 minutes to address the remaining two submissions on the part of the applicant. The first one deals with the right of Rahat on the part of respondents. The first one does the right of Rahat to retain possession of Ruby Saipar, and the second one goes to the obligation of Atania to pay compensation to Rahat for all direct and indirect expenses incurred and accruing as a result of acceptance members of Clan Keen. With the permission of Your Excellencies, I shall now proceed to the first submission in this part and make with the court. Your Excellencies, Ruby Saipar was handed to the Rahadi Ministry of Culture, and it was originally brought by Carla Diogo, who tried to prevent its destruction in the territory of Etania, as well as to ensure the cultural integrity of Keen people. Your Excellencies, to support the respondent's claim on its right to retain possession of Ruby Saipar, the respondent presents the following three arguments. Firstly, Rahat is not obliged to return Ruby Saipar under international law. Secondly, Rahat has legitimate grounds to retain possession of Ruby Saipar. And thirdly, Rahadi possession of Ruby Saipar is aimed at its preservation. Your Excellencies, turning to the first argument, the respondent will prove that neither the 1970 Convention nor customary international law oblige it to return Ruby Saipar to Etania. With respect to the Convention, as it was already stated, the Rahat has only deposited its instrument of ratification at the moment of receipt of the Ruby Saipar, and therefore the only obligation it was bound was the obligation under Article 18 of the Vienna Convention on the Law of
So you
Treaties.
agree with your opponents that you
Yes.
had an obligation?
Yes, Your Excellencies. With respect to this obligation, the Article 18 of the Vienna Convention sets a very high threshold for an act defeating the object and purpose of a treaty as compared to any other violation of substantive provisions of the treaty. Your Excellencies, any other interpretation would mean that there is essentially no difference between the entry into force of the treaty and interim obligations before its entry into force. And Permanent Court of International Justice in the case of Riva Order stated that it might not rely on signed but not ratified Barcelona Convention against Poland, as it would mean, and I quote, that the act of ratification is superfluous formality. End of quote.
But isn't there a difference here that there has been an act of ratification actually? So everything has been done and there is only just a few weeks left until it will come into force, and then you can basically do everything in your power to violate the substantive provisions of the convention.
No, Your Excellencies, of course, the state is not permitted to violate substantive provisions which are not specifically required to be applicable only after entry into force. And the respondent raised the attention to Article 7, which specifies that the provision on return is applicable only after entry into force. However, no other obligation under the treaty was violated by the respondent, and what is more, after entry into force, the convention prescribes a large number of obligations which will be applicable, such as the establishment of bodies entrusted with the observation of transfers of cultural property, the issuance of licenses, and a large number of the other obligations. And International Law Commission, when drafting the Vienna Convention on the Law of Treaties, specified in its 1953 report that what concerns the obligation on return of objects of art arising under the signed but not ratified treaty, hypothetically, to defeat the object and purpose of such a treaty, a state should have destroyed such a property. Your Excellencies, in this case, the good faith retention of Ruby Saipar by the respondent state is not tantamount to its destruction and in no way prevents the operation of the convention.
So you're saying that the object and purpose of the UNESCO Convention does not prevent you from importing stolen cultural property?
Your Excellencies, turning to this point, the convention was aimed firstly at the elimination of black market in cultural property.
Yes
and
or no? Does it object and purpose prevent importing stolen property or not?
Your Excellencies, yes, the object and purpose focuses on the prohibition of illicit import.
But you did import stolen cultural property into Rahad.
Your Excellencies, this act is not attributable to the respondent state. And
why not? You took the Sipar right on your border and very happily carried it away to a museum. Why is it not attributable to you?
Your Excellencies, the very import of the Ruby Saipar was performed by private citizen, by
Yes,
Kovac.
can actions of a private citizen ever bind the state?
Only if the private citizens act on behalf of the state or was entrusted by the state to act in such a manner.
Those are only two criteria?
Or when it may be reasonably presumed that such a person acts with the permission
How
of
about subsequent acceptance of person's actions? Subsequent adoption as actions of your own.
For instance, your customs officers accepting the object.
Yes, Your Excellencies. In this respect, it is essential that if we see the situation in that light, it means that the convention is already in force for the two states and the respondent is...
Now, what you said that object and purpose prohibits illicit import, and your only defense against the illicit import is that it was done by a private citizen. So what you need to do now to protect yourself is to prove that there was no subsequent adoption of actions of Carla Dugo as Rahad's own.
Yes, of course, Your Excellencies. There was no such an adoption.
What are the criteria? Where do you get the criteria for subsequent adoption of actions as state's own?
Your Excellencies, there was no single statement on behalf of the state officials.
There was actions, taking the ruby zipper and taking it into state's possession. Is that not enough? How do you assess the acceptance of some of these actions?
Your Excellencies, the respondent is not aware of particular criteria to assess. However, if we interpret the convention as a whole and not only in accordance with its title, it is evident that the convention is aimed, as is stated in preamble, to prevent the impoverishment of national cultural property and to prevent the situation which might damage the cultural property, as it explicitly stated in the preamble. Therefore, Your Excellencies, turning to the second argument concerning the customary international law to return cultural property to states of origin, the respondent does recognize that there is an area of the General Assembly resolutions favoring such a return. However, as this honorable court stated in East Timor case, when a state practice is conflicting, a very fact of General Assembly resolutions may not be relied upon. And in this context, the respondent emphasizes that states in the predominant number of cases return cultural property voluntarily, meaning that they do it ex gratia, which means that opinion juris is not formed, as it was confirmed by this court in paragraph 77 of the North Sea Continental Shelf cases. The applicant referred to the case of repatriation of cultural objects from Japan to Korea. However, it is necessary to emphasize that 75,000 of cultural objects of Korea still stay in 20 different countries of the world, and those countries refuse to return those cultural objects. Therefore, there is not the case to confirm the customary rule on return of cultural property.
When this court spoke of conflicting state practice, did it really mean that objects of cultural importance are returned sometimes ex gratia and sometimes due to legal obligation, or did it mean that they're sometimes returned and sometimes not returned?
It means that the practice was conflicting in the matter that state acted differently, which means, yes, that sometimes the objects are not returned and sometimes they are.
Can you tell us of any practice when they're not returned? When there are states who say we do not have obligation under international law to return objects?
Of course, Your Excellency, the famous case of Elgin marbles, where Britain does not recognize any
Is there anything less famous than that? Because otherwise Britain could be persistent objector.
Well, the case of Nefertiti burst by Germany refusing to return. Your Excellency, proceeding to the second argument, it concerns the legitimate interest of Rahat to retain possession of Ruby Saipar, and here the respondent makes 2 points. Firstly, its retaining possession of Ruby Saipar is warranted by its significance to Kin population, and secondly, such a retention is consistent with the Rahadi obligations under the human rights covenants. Your Excellencies, when
how did the non-repatriation of the cultural properties interlinked to the human rights issue that was mentioned?
Well, Your Excellencies, considering the fact that nearly 2/3 of Kin population is currently in the territory of Rahat, it has obligations under the International Covenant on Social and Civil, on Civil and Political Rights, and
I'm not sure, but in the compromise we have information that they have been absorbed as your nationals. They are still obtaining the status of refugee or the migrants.
Yes, Your Excellencies, they are not nationals of of Rahat. However, under the covenants, the obligations under the covenants shall cover all people who are within the jurisdiction of the state, and it was confirmed by this court in its advisory opinion on the Palestinian wall. In this respect, the respondent refers to Article 27 of the International Covenant on Civil and Political Rights and Article 15 of International Covenant on Economic, Social and Cultural Rights, both prescribing that individuals shall exercise the full right to take part in cultural life and to enjoy the culture. Your Excellencies, the exercise of such rights, of course, prescribes that states do not interfere in the exercise of these rights, and more than that, access to cultural property is essentially to grant for the people. Your Excellencies, this issue is...
Is the cultural life and the cultural property the same notions?
No, of course, Your Excellencies, the cultural...
Is the participation in cultural life immediately mean that we should have the public display of cultural property at all?
Your Excellencies, the enjoyment of cultural property may be seen as a part of participating in cultural life, emphasizing the fact if the situation is such as cultural objects are of significance to a particular group of a state, which is exactly the case before these courts, as the Ruby Saipar symbolizes the very history and the very traditions on kin population, as well as all other citizens of the nomad coast, and respondent does recognize the fact of it symbolizing unity.
Who is the owner of Ruby Saipar?
Your Excellency, the respondent does not contest the Italian ownership of Ruby Saipar. However, it states that it has override interests that may override the Euro ownership of Ruby Saipar.
So in this case, how long can you keep in possession Ruby Saipar?
Your Excellency, it's impossible to say as of today, as the conditions in Italian territory are still not proved to be satisfactory to return such priceless cultural objects to that state. As long as these conditions subsist, the Ruby Saipar may not be returned. However, if they are, the states may enter into negotiations and settle this issue in a mutually beneficial manner.
Tell me, if you're getting money for displaying this Ruby Saipar in your museum, what are you doing with the money?
If we suppose that we get money,
yes, money for tickets for seeing Ruby Saipar.
Your Excellencies, perhaps we will cover the expenditures on refugees partially.
No, see, my problem is that you display something belonging to somebody else and you don't contest it. And then you basically keep the money for your own purposes. Is that allowed under international law? It seems like basically you have taken the Ruby Saipar for your own financial gain or aesthetic gain or something like that.
Your Excellencies, with all due respect, there are no indicators that it was done for any financial benefit, as it was explicitly stated by Minister of Culture that the very aim of retaining possession of Ruby Saipar is granting access to it and preservation of this priceless.
If, for example, Ruby Saipar would be removed from the public display because of its condition for the preservation, as we have. In this case, you will have the same situation to steal and keep in your territory, saying that it is violation of the human rights of the king.
Your Excellencies, the preservation, even if it's not displayed, is the second essential part of obligations, essentially, of Rahat. So if it is not displayed, it must be preserved as an essential object of culture.
It was preserved, it was put in the storage, and it was stolen.
Your Excellencies, yes. Firstly, the very fact that it was stolen does prove that it was not duly preserved. However, the respondent does not focus on this point, but on the point that the very intention of Athenian government explicitly articulated to ban Ruby Saipar, as it was stated by President Van that they would not tolerate Ruby Saipar. It's paragraph 43 of the compromise, if I'm not mistaken, that the Ruby Saipar became a symbol of sedition, became a symbol of disruptive elements in the Athenian territorium. It does confirm the risk posed to the Ruby Saipar itself. Therefore, such risk may not be tolerated, Your Excellencies. If Your Excellencies have no further questions, I will proceed to the second submission, as it's matters to discuss, Your Excellencies. The second submission states that Atania shall pay compensation to Rahat for its accepting kin people. And in this respect, the respondent firstly emphasizes that it makes its claim on behalf of itself as a state and having no recourse to diplomatic protection. And Your Excellencies, the claim is substantiated as follows. Firstly, Rahat does have standing to invoke international responsibility of Atania. Secondly, international responsibility of Atania is invoked due to grave human rights violations. And thirdly, Rahat is entitled to compensation as an injured state. What concerns standing, Your Excellencies, indeed, this court recognizes the concept of erga omnes partes obligations in Belgium versus Senegal case. And in that case, the court stated that such obligations prescribe a common interest of states parties to a particular treaty in compliance with such obligations in any given case. What is more, Your Excellencies, one of the recent cases where the standing was based on erga omnes partes obligations is claims of Marshall Islands against nuclear powers parties to the non-proliferation treaties. And in that case, the standing was based on Article 42 of Articles on Responsibility of States, meaning that a state may invoke responsibility and claim compensation on behalf of itself. Your Excellencies, considering that...
So wait,
yes,
ICJ and Marshall Islands actually said that Marshall Islands could claim compensation on behalf of themselves?
Your Excellencies, the case was dismissed due to the absence of
Yeah, but
legal...
can you cite the paragraph where the ICJ said that Marshall Islands had standing to bring a claim and ask compensation on behalf of them?
I referred to a memorial of Marshall Island where it based its standing.
Yeah,
on
so
article.
ICJ had nothing. It said nothing about that.
ICJ did not deal with this issue as it dismissed due to the absence of legal dispute between the states. Your
So
Excellencies,
can we conclude that Marshall Island didn't have any standing?
didn't have standing due to the absence of legal dispute, and it's essentially different matter in the case of nuclear weapons.
So do you have precedent where this court accepted the erga omnes principle?
Yes, Your Excellencies, Belgium versus Senegal case of 2000.
No compensation there.
Yeah.
Yes, Your Excellencies, however, the situation was different, and the second essential point is that Rahat is specially affected state in accordance with Article 42. And the commentary to this article states that in order to be considered injured, a state must be affected in a way that distinguishes it from the generality of states to which obligation is owed. And in this respect, the respondent emphasizes that in normal scenario, the consequences of breaches of human rights are confined within the territory of a particular state. However, this state is different as a result of a Atanian violation of human rights of its citizens. 800,000 people.
Still does not explain the question on why you ask money for yourself and not for the refugees. It seems like you're again trying to enrich yourself.
No, Your Excellencies. With all due respect, the money is asked to cover the expenditures which were suffered by Rahat, and having a reference to the fact that the number of refugees accepted by Rahat corresponds to roughly 1/3 of its population, which placed a tremendous burden.
It's number of people you call refugees. It's not refugees. You still need to prove that.
Yes, Your Excellencies. Proceeding with your question, the respondent essentially cannot claim compensation on behalf of the kin, as they are not nationals of the respondent state, and the possibility to claim compensation on behalf of refugees referred to by the applicant state in their written memorials is no more than the provision of draft articles on diplomatic protection, which are not even approved or adopted. Yes, Your Excellencies. Then proceeding directly to the wrongful act of the applicant state, the respondent claims the accumulated violations of Article 2 and 11 of International Covenant on Economic and Cultural and Social Rights. Article 2 stating that no discrimination shall take place while the rights are satisfied in accordance with this covenant. And what the respondent submits that the RAB Act ab initio was discriminatory as it favored profit-generating farms, neglecting the interests of subsistence farmers, 98% of which turn out to be constituted by kin people.
You're asking us to develop international law in a very significant manner, to allow other countries to come and claim something about violations of human rights in other countries. So, are there any limits to such claims? If there was one kin member which was severely discriminated against and deprived of water, could you come before us or is there a numerical limit, or is there a certain criterion? Where does this right kick in?
Your Excellencies, the respondent supposes that both objective and subjective criteria may be taken into account. Objective, yes, numerical issue matters as the situation was grave enough. However, the subjective criteria is that a state may not be left unpunished for grave human rights violations.
What are grave human rights violations?
Yes, Your Excellency, in accordance with the International Covenant on Economic, Social and Cultural Rights, a minimum core obligations shall be satisfied with respect to its population, and what is constituted by its minimum core in this case is that, according to General Comment number 20 to the Covenant, under no circumstances, even in situation of unpayment, a state may not deprive its population of food and water, which are essential to their lives. And therefore, Your Excellency is considering that this deprivation of the very essentials took place.
So basically, if I don't pay a bill for my water at home, then state cannot cut off my water supply? Is that how it is?
Yes, Your Excellency, the water supply cannot be cut off in such a manner as to deprive you totally of the water and to subject you to the
And
inadequate
that's
standard.
the fundamental human right, right?
Minimum core obligations, yes, it corresponds to fundamental human rights. Your Excellency, summarizing this submission, what the respondent states that considering the fact that these violations of fundamental human rights together with the discriminatory element which took place in accordance with the RAP Act of Atania do amount to persecution in Atenian territory, and therefore, may I please end
You can finish the sentence.
do amount to persecution of kin people, and therefore give basis for qualifying them as refugees. Therefore, the Rahat might not have expelled them. Thank you, Your
Thank you very
Excellencies.
Applicants, would you like to exercise your right to rebuttal?
Yes, Mr. President.
To rebuttal,
Mr. President, Your Excellencies, in applicant's rebuttal, I will cover the three issues with regard to interpretation of Article 6.3 of the World Heritage Convention, respondents standing to claim human rights violations, and the right to control the Ruby Seeper as a specific right under general right to culture under the ICCPR and ICESCR. With regard to the first argument, first issue, Your Excellencies, with the interpretation, respondent interpreted Article 6.3 of the World Heritage Convention as a due diligence obligation. However, it is a strict obligation since it clearly states that a state may not take any measures which might cause damage on the territory of other states, and thus when a state knowingly takes such measures, it violates this provision. In the case at hand, respondent, according to its environmental impact assessment, the concerns expressed by the World Heritage Committee and by the putting of this object in the World Heritage List in danger, understood that it might cause damage to World Heritage, and thus, in taking such measures and failing to mitigate them, such as the Somali pipeline operation, it violated this obligation. With regard to the second argument regarding the standing, Your Excellencies, it is still our contention that respondent failed to demonstrate such standing, referring to the non-decided case of Marshall Islands and the Belgium versus Senegal case when the court did not order compensation and the Belgium was a non-injured state. And when a state is injured, it has to demonstrate the exhaustion of local remedies, which is a customary rule of international law and was codified in Article 44 of the Articles of State Responsibility applying to injured states. And finally, with regard to the justification of the retention of the Ruby Seeper by preserving the cultural rights of the clan kin, Your Excellencies, the general right to culture cannot justify such a retention because a specific right to maintain and control cultural property is applied only to indigenous communities and only with regard to human remains and ceremonial objects, while the clan kin is not recognized as indigenous community, and since the Ruby Seeper is not used in any religious ceremony and is not a human remain, the right to control and maintain cultural property cannot be applied and cannot justify the retention of the Ruby Seeper. That concludes the rebuttal of applicant. Thank you for your kindest attention, and may it please the Honorable Court.
Thank you.